Hey everyone, Paul Vojchehoske here, and welcome to the Real Estate Classroom YouTube channel. Just a place that if you're studying for your real estate exam, we help you pass that exam the first time. Okay, in today's real estate exam prep video, we're going to discuss a concept that you have to know called Earnest Money Deposit. I actually received an email from a student that said, hey, when are you going to do a video on earnest money deposits? And quite frankly, I thought I already had, but it turns out that I hadn't, so I put it to the top of the list. So this week, the topic is earnest money deposits. Okay, so what is an earnest money deposit? How does it interject itself into the entire real estate transaction? And what are the things that you have to know as not only a real estate professional, but more importantly, as a student studying for the exam? So understand that earnest money or the earnest deposit is typically money, all right? And when I say money, it comes in the form of a check, cash, or a money order. That's 99.9% of the earnest deposits that we see. However, it's very important to understand that earnest deposits, it doesn't have to be money. As long as it's a legal object, it can be anything. It can be a pile of dirt. It can be diamonds or gold or stocks or a promissory note. It has to be legal, though. What would not be legal and legitimate earnest deposit would be a pound of cocaine, all right? So keep that in mind. It doesn't have to be money. It typically is. It can be something else, but very important, whether it's money, gold, a pile of dirt, promissory note, or whatever, it has to be directly and objectively written into the purchase offer so the seller can look at the purchase offer and determine what type, if any, of an earnest deposit there is. All right. And the earnest deposit or earnest money, how it's typically referred to, is it's an amount of money that is put down by the buyer with the purchase offer, and it represents a good faith. All right, it's sometimes referred to as a good faith. Now, in some states, earnest money is referred to, and this is important. In some states, earnest money deposit, the earnest deposit is referred to as hand money or binder. Why that? So if you live in a state where that is prevalent terminology, understand that on your state side of the real estate exam, they're going to use those terms referring to earnest deposits. But at the same time, on your national portion of your exam, the questions are going to refer to earnest money or earnest money deposits. All right. And understand this, that the earnest money deposit or the value of the item that is given to the seller for that earnest deposit, such as a diamond ring, is going to apply or be credited towards the total funds that the buyer has to bring to closing to close that real estate transaction. And also keep this in mind that in all 50 states, there is a statutory or regulatory process of how brokers have to, basically the workflow for those earnest deposits. And it's codified, so brokers have to really follow those workflows diligently, because that's one of the things that in almost every state a broker could lose their license for. And again, those are going to be determined by state law or state regulation. And also remember this, the state law or regulation is a baseline. However, the buyer and seller can, through the contract process, agree to alternative methods of delivery. So for example, it's very typical that an earnest money check be written to the broker or written to an escrow title company. However, if the seller wants it written to them directly and the buyer is okay with that, they would write that in the contract. The key to remember is any alternative to what state law says has to be written into the contract and agreed to by the buyer and the seller. So there's two additional questions I need to address in this real estate exam prep video, because we get this question from students all the time. And quite frankly, these are questions, or these are the type of questions you're going to see on your national side of your exam. One of them is, What is the statutory maximum under state or federal law that's required for earnest money, or what's the minimum required by law? Or what, and we already addressed this, but does earnest deposits or earnest money deposits always have to be money? Can they be something else? So it's real important to remember that number one, yes, it does not have to always be money. It can be something else. But again, buyer and seller have to agree to it in writing in the contract. But how much does earnest deposits have to be? And the answer is, it is an item that is negotiated between the buyer and seller. There is no law, state or federal, no regulation that requires earnest money to be X, Y, and Z. It can be zero, it can be $1, it can be 20% of the purchase price, it can be whatever the buyer and seller negotiate in the contract. Remember, the amount and type of earnest money is no different than the purchase offer and the closing date that's being negotiated and inspections that's being negotiated, those type of things. It's just one component of a purchase contract. Okay, in this section of this video, I want to discuss the workflow of the earnest deposit and how agents have to adhere to the process. Okay, very important. There are 5 different options or workflows that you as a real estate student need to understand. Now, there's probably more, and a lot of it depends on the jurisdiction that you're operating in. However, for the real estate licensing exam, we're going to limit it to these 5. These are the most common, right? The first one is, this is where the listing company is conducting or closing the real estate transaction. So keep in mind, either the listing broker is going to close the real estate transaction, or what we call a third-party escrow closing company. Now, that escrow closing company can be a company that's all they do, or it can be an attorney's firm. Many attorneys will do real estate closings as well. So I'm just kind of clumping those two together. So we have the listing broker or the escrow closing company, which includes those attorneys that close a real estate transaction. All right. So depending on who's closing the transaction is going to determine the workflow of where that earnest money check or that earnest deposit goes to. And it can be quite complicated if you've never been introduced to this. So the first option or the first workflow I want to talk about is the earnest money check that the buyer is writing at the time that the purchase contract is written up is delivered and deposited into the listing broker's trust account. It's a checking account, okay? That listing broker's trust account. Now, that can be delivered directly from the buyer. It can be delivered to the listing broker directly from the buyer's agent or the listing agent. It doesn't matter how or who delivers the earnest check to the listing broker. What's important is that earnest check is delivered to the listing broker, and the listing broker deposits that check or that cash or money order into the broker's trust account. Now, the money that's been deposited or that check that's been deposited will stay in that listing broker's trust account until that transaction is consummated, which means it is closed, or the deal is terminated, and then the funds are dispersed to whoever is supposed to get it. And we'll talk a little bit more about who gets that at the end of the video. All right, I want to talk about option number 2, or what we call workflow number 2. This is where the earnest money check that the buyer is writing, remember, they're writing this check at the time that they're submitting the offer or writing the offer to purchase, right? So the earnest money check is deposited into the buyer's broker's trust account. Remember, in this scenario, the buyer has their own agent, their own broker to represent them. So when that buyer and that buyer agent or buyer broker sat down to fill out the purchase contract, at the same time, the buyer is cutting a check. So that check is deposited into the buyer broker's trust account. From there, the buyer's broker is going to write a check out of that trust account to the listing broker's right? And the listing broker is going to take that check and deposit it into their own trust account. Because remember, every real estate broker must have their own trust account. Now, it will remain in that listing broker's trust account until the real estate transaction is consummated or terminated. And again, this is where the listing broker is going to close the real estate transaction. All right, let's talk about the third option for the workflow for earnest money. And this is where an earnest money check is obviously written by the buyer at the time the purchase contract was drawn up, and it is deposited into the buyer's broker's trust account. Then the buyer's broker will write a check from that trust account to the listing broker's trust account. So then the listing broker is going to take that check and deposit it in their own trust account. Then the listing broker is going to write a check from their trust account to whatever third-party escrow closing company that's going to ultimately and finally close the real estate transaction. So there's a lot more moving parts in option number 3, but it is a workflow that is fairly common in today's real estate world. Option number 4, this is where an escrow closing company closes the transaction. The earnest money check is written directly to and deposited into the escrow company that's going to be doing the closing, the title and escrow company's trust account, because escrow closing companies need to have trust accounts as well. All right. So in this scenario, it's important to remember the distinctions here. So when the buyer's agent or the buyer's broker sits down with the buyer to fill out that purchase contract, and then they're going to write out the earnest check, the earnest money check, excuse me, what happens is, instead of the buyer writing the check to one of the brokers, they're writing the earnest money check directly to that title and escrow company. So then someone, whether it's the buyer or one of the agents involved in a transaction, they're going to deliver that check directly to the title and escrow company, who then must deposit it into their trust account until the deal has been consummated or terminated. And then finally, option number 5, this applies whether there's an escrow closing company that's going to close the transaction or if there is a listing broker. This is where the earnest money check is written directly to the seller. All right. It's not common in most transactions. However, it is very common in new construction where the buyer does, in most jurisdictions, they cut that earnest check. Sometimes, in some states, we refer to that as a builder deposit. They cut that check or write that check directly to the builder or directly to the seller. And then the seller deposits that money into their own checking account or savings account or spend it or whatever they want to do. But understand this, it's dangerous. And as a real estate professional, we don't like to do that. However, if it is done that way, the buyer does get credit at closing. That is considered a credit on their closing disclosures. And as I said, here's the thing. No matter where or who that earnest deposit is given to, or what type of deposit it is, whether it's a ring or money, it has to be clearly stipulated in the purchase contract for the buyer and the seller to both agree to how much and what type of earnest deposit it's going to be. Now, one last thing that I do want to point out here, which I don't have a slide for, but very important. This happens where earnest monies are large and the closing is a long way away. So it's not uncommon in some types of commercial real estate or even industrial, where we're talking millions of dollars for a purchase, and we're also talking about a year, 2, 3, or 4 for a closing. So I may go put an offer in for $10 million on this huge piece of industrial property, but it's going to be 3 years before it closes because of all the environmental assessments I have to have done. And I may put a $1 million earnest deposit down. Well, if I put it into a broker's trust account, it is making 0 interest. So I want that money to make interest. So the buyer and the seller can agree in the contract that this earnest deposit is going to be put into, let's say, a money market account or a savings account, so interest can be earned on that money. The purchase contract will also determine who gets paid that interest, but it is an alternative that's available. But again, the important thing to remember is the buyer and the seller are agreeing to that alternative method of workflow for that earnest deposit. Now, last but not least, I want to talk about disputes. When there is a contractual dispute for any reason, remember, we're not attorneys. Attorneys and judges and things like arbitration and mediation, they settle disputes, we don't. Almost every single contract in today's real estate world has some type of arbitration, mediation provision, or they have a right to go directly to court to settle any dispute. So if a buyer and seller are in dispute, whatever the case may be, along with that dispute is the earnest money. Who gets that earnest money? So if there is a dispute, what you need to know is that money is kept in whatever trust account that it is currently in, and it'll stay there until the dispute is resolved. Now, many states, and remember this because you might have this on your state portion of your exam, many states do have a time frame in which, if, let's say, for example, if there is a dispute and the earnest money is still in the trust account 1 year later, 2 years later, whatever the state stipulates for a time frame, then the broker that is holding on to that earnest money, or the title and escrow company that's holding on to that earnest money, it will provide them options on what they may or may not be able to do with it. One common thing that's out there is if the buyer and seller decide to go to small claims court, or it goes to court for any reason, or they've lawyered up and it looks like it's going into a lawsuit, many contracts have a provision in there that allows the broker that's holding on to that trust money or that earnest money to send it directly to the court system, where the courts act as that trust account there. So basically then the broker or the title and escrow company can get it off their books, and then the buyer and seller can hash it out in court. So anytime there is a contract dispute, remember the earnest money goes along with and is a part of that dispute. If you're going to continue studying, I suggest you check out this real estate exam prep video right here. And if you have not subscribed to the channel, please do so. Click the little circle to my left here. Comments and questions down below. I would appreciate it. That's all I have for today's video. Thanks for hanging out. I know it was a long video. I'll see y'all in the next video.